Okay, while they're at sidebar, let me bring in our guest standing by in Atlanta, Georgia. Criminal defense attorney and former prosecutor Marsha Minow is with us. And in New York City, former prosecutor Imran Ansari is with us. Great to have you both. Marsha, I want to begin with you. What do you think of these cross questions?
I think it's a complete waste of time. Counsel is not getting to the facts and to the evidence. Asking this witness to explain why or why not he said something instead of using the inconsistent statements as impeachment and then saying to the jurors in closing that he was impeached and that he's not truthful and should not be believed should be the strategy. And all this time on the stand is just clouding what this case is really about.
Very well said, Marsha. Imran, talk to me about these long questions, please. It seems like this is a great example of what not to do on a cross with a long question like that. They can't even figure out where the answer starts and begins, and no wonder they're going back to the court reporter.
Yeah, no, Julie, I think you feel the frustration of John Lewin in the way he's asking questions. Of course, he's been doing this over the course of a few days now, and you hear Robert Durst basically saying your line, I'm looking at my tablet and your question's 6 lines long. That's a problem. So you don't want to have these compound questions on cross-examination. You want to be pointed, direct, and try to box that witness into testimony that's ultimately going to help you prove your case at the end of the case. But here we have John Lewin, and you sense that frustration in his voice. You've seen him peppering Robert Durst over the course of a few days with these cross-examination questions. And they're getting longer, they're getting more compounded, and that's not necessarily something you want to do on cross-examination. And I think Robert Durst has his wits about him. He knows how to handle John Lewin now. He knows how to frustrate John Lewin in his responses, and he throws things back at John Lewin. And I think that's why you're seeing the questions getting longer, and they have that air of frustration with them.
Right. Oh, definitely. He knows how to get under his skin. They both know how to get under each other's skin. That is for sure. And with John Lewin, you know, when you're asking the questions, it seems like everybody's lost right now, right? It seems like everyone is lost, and this jury's got to be frustrated. Marsha, I want to talk to you about yesterday. Something big happened toward the end of the day after the jury was sent home. This was a little bit of a surprise because many of us thought that maybe the judge was just going to allow this cross to go on and on. It's a week today. And the judge said to John Lewin, tomorrow will be your last day. And we saw John Lewin pushing back on that, saying, Your Honor, I need more time. And the judge saying, well, depending on how tomorrow goes, we're going to see if you need to go into Monday. Tell me what you think about that, your experiences, please, in having a judge intercede and saying, okay, anything more than this is just cumulative and perhaps a waste of time. And now I'm getting word that they're back. So I'm going to ask you to hold your answer. Marsha and Imran, thank you both. Today, it seems that His Honor is taking that morning break a little earlier than they typically do. It seems like a lot of confusion over finding back that testimony. These cross-examination questions are certainly not short and sweet, as is recommended when you do a cross-examination. They are long, they're including hypotheticals, many of them are compound, and some of them seem a bit repetitive. And we heard His Honor yesterday saying to John Lewin, you really have to wrap up tomorrow. I'll potentially let you go into Monday, depending if there is a need. But he believes that this has been a very effective cross. He said that in open court, said you've made your points effectively, Mr. Lewin, and anything beyond this could be a waste of the court's time. We know that there is money involved any time that there's a day of court. There are lots of court costs involved. And he felt like anything beyond what we've seen already could be cumulative, which is not allowed either. And I was just posing that question to our guests, so let me bring them back in. Marsha Minow and Imran Ansari standing by for us. Marsha, I was going to go to you first on this one. To ask you, in your experience, have you seen the court intervene ever in a trial when an attorney is carrying on too long, or perhaps the judge used the word proportionality? He said this cross has to be proportionate to the testimony given. I wondered if you've seen any kind of intervention like that before.
I have. Courts have the legal authority to stop you as counsel, whether you're the prosecutor or the defense counsel, and find that you have exceeded the scope of the evidence or you've exceeded the scope of the direct examination if you have someone on cross. Courts are very cautious about judicial resources, and they don't like lawyers wasting time of the jurors. He also received a note from this jury asking, when is this going to end? Once the judge hears that, of course, he's going to limit the prosecution's time.
Yes, yes. And I want to play a clip from earlier today with the cross-examination. And this was before they kind of got lost with the questions. John Lewin was really pressing him on Susan Berman.
Would you agree that if a close friend of yours who you've given a large amount of money to over the years, you become aware 5 years before they die that they are out there falsely stating that you confessed to killing your wife to them and that they cooperated in falsifying an alibi, wouldn't you believe that that person would be really taking advantage of your generosity?
Well, that person is Susan Berman, and I valued her friendship, and she did what she did.
So you're saying, Mr. Durst, that in essence you made the decision that even though she was falsely claiming that you had killed your wife to numerous people and you were aware of it, you decided that you were not only going to remain friends with her, but you were going to continue to give her large sums of money.
Correct.
Oh, that first question. Imran Ansari, this seems like a great example of what not to do in a cross. You were just making the point before we went back in about how you want to box a witness in. How in the world could he be boxed in with a question like that?
Yeah, you never want to have the witness have the ability to explain away a question that you are seeking to elicit certain testimony on cross. Leaving an open door with a question which is not a leading question on cross could expose you to a lot of vulnerability in terms of how that answer is going to be answered. And especially when you're dealing with someone like Robert Durst, this is someone who has gotten away literally with murder in the past. He knows how to handle the courtroom. He knows how to handle prosecutors, and he knows how to answer questions. We've seen that throughout the days of questioning. So you never want to ask a question where you can't really either impeach the witness on prior inconsistent statements or box them in with a leading question to a yes or no answer or an answer which is going to give you what you want. You never want to give them that open road, especially with someone who really is smart. You can't deny that Robert Durst is a smart individual. He knows how to perhaps manipulate the questions that he's presented with and give certain answers in a certain manner. So you never want to do that. You never want to give that opportunity. And here, you're asking these questions after days of testimony. You got that note from the jury. That's an indication that you want to cut out, you want to end your cross and move on.
Exactly. Very well said. Imran Ansari, Marcia Minot, it is a real pleasure having you both with us today. We want more analysis from you. We're just going to squeeze in a break while the jury's on their break. Don't go anywhere. Court TV Live continues this Thursday afternoon after this. Thanks for being with us today here on Court TV Live. I'm Julie Grant. The jury's still on their break in the Jinx murder trial in Los Angeles. And we were just discussing a few moments ago how last night, right after the jury was sent home, the attorneys were still in front of His Honor. And the judge said to John Lewin, who is the deputy DA leading the prosecution of Robert Durst, that he really needs to move the cross-examination along and that he would like him to finish it up today. And so we want to go back and play those moments for you now so you can see what the judge said and what the response was.
Under People versus Shazier, 60 Cal 4th 109 at 142, the prosecutor was entitled to explore reasons why information or opinion supplied by a defense witness might be less credible and reliable. For example, because of the witness's personal biases, evasiveness, or lack of familiarity with the relevant facts. That allowed broad cross-examination on over the objection of argument. The other case in Chapman, which I referred to previously, court should carefully scrutinize "they were lying" questions, that's in quotes, In context, they should not be permitted when argumentative or when designed to elicit testimony that is irrelevant or speculative. However, in its discretion, a court may permit such questions if the witness to whom they are addressed has personal knowledge that allows him to provide competent testimony that may legitimately assist the trier of fact in resolving credibility questions. And indeed, Mr. Durst has been confronted with things that he does know, and the questions go to his credibility. But sometimes there are objectionable questions and there is no objection posed. I do sustain objections to argumentative questions, so I don't think the defense can invoke futility here. So I know there's some frustration on the part of the defense that they don't seem to understand how I can allow these questions. The reason I'm allowing them is the authority that I've just described. So nevertheless, at times the questions become argumentative, and there is a bit of repetition there, though that's not a valid objection, but to the point of not using too much time. In many different areas, there is a slight misuse of time, Mr. Lewin, and you do take more time than you need to take, and that adds up, so that cumulatively we have a problem, which I'm trying to address, and I will address, by limiting your cross-examination. So we'll see how you're doing at the end of the day tomorrow, and we'll see how much more is permissible. But you certainly may cover that subject matter that you described, but you can figure it out. You're a very good lawyer. You can figure out how to do it.
Let me propose something that might be of assistance to the court. The court is willing to let me have to the end of the day on Monday. I will not call the witness that I was going to have to call, the detective, to go back through to indicate all of the pieces of evidence that are in discovery that Mr. Durst is disputing. I will not call the Lenox Hill people regarding anything relating to the residency. I will basically take the court's observation that in essence, any person who's, and this is my paraphrase, not the court's, but that in essence, unless the jury is not paying attention, they cannot buy off on the residency issue, the match, etc. I won't call that witness. I will not call Detective Becerra, who I was going to call back to the stand. I will not call Bill Mayer, who I was going to call back on rebuttal. I will restrict my rebuttal to Andrew Jarecki and that one area. That cuts our rebuttal down from at least a day to about a half an hour. I'm going to ask the court if I agree to do that. The court already said we could have that day of rebuttal. I'm going to ask that the court, Your Honor, let me have, because I have to plan this out. I can't be in a position where I don't know what I get on Monday. So in exchange, Your Honor, that's a fair time exchange. I'm asking that I be given till the end of the day on Monday, and we will have our one rebuttal witness on Tuesday.
So I appreciate that, Mr. Lewin. So that is a very important consideration for me tomorrow at the end of the day when we see how you do, as well as whether the witness, for some reason, causes you to need additional time. But that's well taken. So, Mr. Chestnut.
I make a motion that you hit the bell.
Oh, before we do that, so we have a juror. I'm sorry, not a juror, but on account of a juror, we're breaking early on August.
All right, let me bring back in my guests on the show today, Imran Ansari and Marcia Minot. Imran, I want to start with you. What was jumping out at you as you were watching that exchange?
Well, John Lewin, he's bringing up that he has the opportunity to bring a rebuttal witness. He's sort of limiting, but what strikes me is that he wants more time with Robert Durst. He doesn't feel that perhaps he's gotten what he wanted from him. But as we were talking about earlier, Julie, I think it's at the point where you may have to just say, all right, I got what I'm going to get out of this witness and move on and close it out. But I think John Lewin is so personally invested in this case. It's almost like a Moby Dick scenario where he's Captain Ahab and Robert Durst is his Moby Dick. He needs to take him down. So he wants him on the stand still. He's looking for more time from the judge to keep him on the stand. It sounds like he's making concessions. in terms of the rebuttal case that he may have intended to put on, so he could have more at Robert Durst. But I guess we'll see at the end of the day what the judge rules on that.
I love the way you just put that. That's a great way of looking at this. I mean, we know this is a guy who has invested years of his life. To his credit, John Lewin has spent years on this case. He does cold cases. That's sort of his specialty, if you will. He's a deputy DA, meaning he is a supervisor in that very large office in Los Angeles County, so certainly well respected, very seasoned. But the way he's going about this, Marcia, it's so unconventional to be asking these long, open-ended questions and posing hypotheticals. To the point that Imran just made, do you think this could be why he's going about that? Why? Because clearly he knows how to run a trial. He knows how to do a proper cross, I'm sure. This is not proper. What we're seeing, we all know that. Your thoughts on maybe the why behind it?
I think when you become overzealous, over-invested in your case as a prosecutor, you can lose yourself in the weeds. And it is clear that that's what's going on here with Mr. Lewin. You're an excellent attorney. You know how to cross-examine witnesses. You've litigated several cases over the years of your career, but you've got such tunnel vision in terms of getting at Mr. Durst that you've overestimated your abilities in cross-examining him and totally forgotten about the evidence that you want to present. He is willing to concede what rebuttal witnesses could be assisting him in proving his case, and he's deciding not to do that.
It's really something. It is great to get your insight. Marcia Minot, Imran Ansari, thank you both. You're going to stay with us, and we want you not to move either. We're just going to squeeze in a quick break before the jury's back. This is Court TV Live, your front row seat to justice. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host, and it's great to see you on this Thursday. We're on two coasts for you. We're on the East Coast with the R. Kelly sex trafficking case that's happening now, and also on the West Coast with the Jinx murder trial. We're on day 7 of just the cross-examination of Robert Durst, and the jury is still out on their break. So it is roughly 10:30 Pacific time, and the judge took that morning break a little earlier. There's been a lot of back and forth and confusion with transcripts being read back and Robert Durst arguing with DDA Lewin about what he said or what he didn't say. I've still got my guest standing by. Criminal defense attorney and former prosecutor Marcia Minot is in Atlanta, and trial attorney and former prosecutor Imran Ansari is in New York City. Great to have you both here. And I want to get your take on something that's been going on the last couple days. I'm wondering if we're going to see more of it today, and that is the back and forth between John Lewin and Robert Durst about perjury. And you both know perjury is a crime, of course. And here yesterday, I mean, there was kind of an exchange that got a little funny. I mean, funny but not funny, where Robert Durst is admitting to committing perjury, but saying, well, it's minor what I said or didn't say. I was confusing Christmas and New Year's. And Imran, knowing how John Lewin is and how invested he is, he's been keeping track of all of these times he is saying Robert Durst is perjuring himself. Would you be surprised if he were to file perjury charges at the conclusion of this case?
Yeah, so Julie, if the case does not go John Lewin's way, meaning he doesn't secure that top count conviction that he's gunning for on Robert Durst, then again, it goes back to how we were saying he is so invested in this case and in quote unquote taking down Robert Durst that it wouldn't surprise me if he went back and filed perjury charges. So perjury charges, it's that sort of tricky thing that, you may have someone perjuring themselves either in a statement or during testimony at trial, and subsequently there's a question, do you take that case or that incident of perjury and actually prosecute it? And it doesn't always happen, especially in busy offices. But of course, there's also the level of perjury and the effect of that perjury that's taken into consideration. It's almost like a bail jumping charge. When I was a prosecutor, I would have defendants who would abscond, and then I would have the decision, do I go in and indict this person on a bail jumping charge? And if it was a serious enough case and the individual had a track record, a big rap sheet, maybe I'm going to go in and I'm going to stick on that bail jumping charge to what they're facing in court already. Does John Lewin do that here in Robert Durst with Robert Durst? I think we have to see the end result of the trial. But if it is an acquittal on that top count, then John Lewin may be thinking, well, you know what? Now I'm going in. I'm not letting him go that easy, and he may be seeking that perjury charge.
Yeah, I'm with you on that one. I think depending on which way this goes, we may or may not see that happen. Marcia, tell me, I know we really want to tap in your criminal defense experience here. Robert Durst seems to be answering questions saying, well, I committed a perjury, but it was a minor perjury. He said something to that effect. And I was kind of cringing hearing that because I'm thinking, oh my gosh, he's saying perjury. Why didn't he just say, well, I was mistaken or misspoke or something? Do you think Dick DeGuerin maybe had a talk with him yesterday after that?
I'm certain he did. As defense counsel, you can tell that this is raising Mr. McGarren's blood pressure, because to know that your witness is testifying in a manner that you think is harmful to his defense is very, very scary and stressful during that process. However, Mr. Durst seems to be a charismatic, matter-of-fact, will concede and not concede when it's necessary. So I don't know if it's even causing any problems with the jurors, because sometimes they're even laughing when he's making these comments.
So true.
Okay,
Marcia,
that was
thank
really,
you so
really
much. Let's go back
relaxed
in
because the
line.
judge
Overruled the objection, yet Dick DeGuerin just spoke out. Judge, we really need to have a sidebar. He said it several times. The judge is allowing this. Let me bring back in our guests, Marcia Minot and Imran Ansari. Marcia, I want to go to you first, please. How about that? I mean, it was overruled, yet he kept persisting. Some courtrooms, the judges don't like that.
They don't, but they have to be careful that counsel doesn't do a speaking objection the next time and says something that the jurors would hear that would destroy the case.
Right. Boom. Exactly. That is why you have to have a valid basis, whether it's speculative, hearsay. There are so many different valid bases for objections, but just to say, Your Honor, we need to go to cyber, that's not one of them. So you're right, Marcia, he needs to be careful. And I think the court seemed to be feeling like it was trying his patience a little bit. You heard him saying it's been overruled. There's no need for this. Imran, why do you think they're fighting so hard to keep this out when Robert Durst he kind of said, well, I don't know where I got the stamp. I could have gotten it at her house. He sort of qualified his answer saying, yeah, maybe, essentially. What do you think Dick DeGuerin doesn't want this jury to see?
Well, I think perhaps Dick DeGuerin doesn't realize what he doesn't want the jury to see, but he's taking the measures leading into this line of questioning to perhaps stymie some of the questions that is going to be presented by John Lewin on cross regarding this stamp. And sometimes you see Dick DeGuerin make the objection. He doesn't really articulate the basis of the objection. And trial attorneys sometimes when a line of questioning is going into an area that they're not sure the question and answer response from the witness, how it's going to play out, they try to buy some time. So maybe the objections were made by Dick DeGuerin. He couldn't really articulate the basis of the objection at that time. So what is he doing? He's requesting a sidebar. He's now going to approach the judge with John Lewin, and perhaps he's going to be inquiring as of John Lewin as to the scope or the substance of the questioning from John Lewin going forward. That will give him an idea as to what to expect. So it could be a trial technique. Sometimes you use these techniques as things unfold in court to your advantage.
Thank you so much. They are back from the sidebar. Marcia, thank you as well.
The objection's overruled, subject to a motion to strike if there is not a foundation laid.
The objection is foundation.
Yes, subject to a motion to strike, which you may renew.
Mr. Durst, on the left side, you recognize the cadaver note, correct?
Correct.
That's what you sent, correct?
Correct.
And obviously, you put the stamp on there at some point, correct?
Correct.
And on the right side are stamps from Susan Berman's date planner from her house. Do you see those?
Yes.
Would you agree, Mr. Durst, that they appear to be the same kind of stamp?
Yes.
So my question to you is when you say you do not remember getting the stamp from Susan Berman's house, are you saying, you know what, I'm pretty sure I didn't get it there, or are you saying, you know what, I have no idea, I could have gotten in there, I just don't remember? Which is it?
I never knew up until this minute that the stamps in Susan Berman's house were the same kind of stamp that I put on the cadaver note. I don't remember taking a stamp from Susan Berman's house. I also don't remember getting a stamp anyplace else.
So is it fair to say then that when you look at this, you easily could have taken a stamp from Susan's house?
It's possible.
Okay. All right, I want to talk specifically about the cadaver note. You have now conceded, obviously, that you are the author of the cadaver note, correct?
Correct.
For 20 years, though, you adamantly denied writing the note, correct?
For 20 years, I denied writing it.
You denied that during interviews with Andrew Jarecki, correct?
Correct.
But you did also state, in addition to denying it, have you repeatedly stated, Mr. Durst, that whoever wrote the cadaver note had to be Susan's killer?
I said that to Andrew.
And, Mr. Durst, were you definitive in what you said about it?
I don't know what you mean, was I definitive?
RD 025, 121310, page 681, line 14 to page 682, line 8.